we have proposed a solution whereby if the leaky weir and the works fits within a framework that the government has already specified and agreed to, then the property owner can just go out there and build it, and then it gets certified later. So it takes out all that pre-approval planning process at the moment that is causing such heartache.
Planning law seeks to regulate behaviour so that what is built is consistent with good planning practice, and in this particular instance, the works that have been done in the past have been done as work that may not have needed approval in certain zones. Land in each of our local government areas is zoned for particular uses, and the work that we're talking about here, this type of activity, is being taken place in rural zoned areas. Under each of those councils have their own plans that define what is permissible in those zones, and in many rural zones under the standard instrument that defines those plans, things erosion protection works can either be works that can be undertaken without consent or works that require consent. And when you get to the position where it's a work that requires consent is where you need a development application. Councils, if they have a plan that requires consent, are not at liberty to say, oh, we'll just turn a blind eye to what you are doing and allow you to go ahead without consent. They're constrained by their controls and by their plans. And so when you come into an area, into a council, into a catchment area, as happened in the neighbouring catchment to the Mulloon catchment, where any type of works of this kind needed development consent, you then need to go through the development application process, and it has and in circumstances where the work that's being carried out is not something that is usually assessed by local council officers. That's not to say that some councils may not have expertise in that area, but it would be unusual. And there are a number of other approvals that need to be obtained to carry out those works under a wide range of pieces of legislation. So because we talk about the concern about how something is carried out in a way that does not cause environmental harm or damage to the planning and use regimes in a council, what we're thinking about is a way to streamline that doesn't remove controls but provides a pathway for defined, as we said, codes or a defined description of a leaky weir. We decided leaky weir may not be the term we use in legislation, so we're thinking we might use the term of Landscape Rehydration Works. And
Trudy weirs.
Trudy weirs. Not my weirs. And so what we've done is thinking about a different pathway that doesn't remove all controls but streamlines them. And if anyone's a developer or looked at doing works under local environmental plans, they may have come across the concept of complying development. Complying development is still development that requires consent, but instead of going to council and lodging applications, if your works fall into the framework that satisfy the development controls that are within an instrument, in this case, State Environmental Planning Policy Infrastructure, then you can get that signed off by a certifier who has expertise in that area. And we've drafted an attempt to create a complying development scheme for these, and we've presented it to the Minister, and subject to the department reviewing it, they can see that this is a possible pathway. Now, where you don't need consent under an instrument, and you're doing works that fit into the category of environment protection works, you won't need planning approval to go forward. But in many areas you will. And this will mean instead of going to the council, you have a more streamlined pathway that really sets out some controls that if you comply with them, you'll get a complying development certificate and go ahead and carry out the work. So this is our hope that that these pathways, these slightly streamlined pathways, will be approved and legislative change can be made. Just minor legislative change, doesn't require going back to Parliament. It just means adding an extra couple of clauses into the SEP infrastructure, and this will then mean that not just people in Mulloon, and as is the goal for the Mulloon Institute, that farmers everywhere can go to that instrument and say, oh gosh, if I need consent in my council area, if I'm doing a leaky weir, a landscape rehydration work that satisfies these controls, I can do it as complying development and go ahead. Now, that said, as Wilf raised, we've got to coordinate both the planning and the water law, but on top of that, there are, of course, other interested legal parties. We have legislation with other approval requirements. So the package is not just, let's just change that, let's just change that. What we want to do is work with Parliament and the different departments to come up with a package that addresses the Fisheries Management Act. Then we also address Local Land Services Act, the Biodiversity Conservation Act. All of those acts have their own requirements for doing works that disturb native vegetation, that interrupt fish passage, etc. So it sounds simple, and we think we've got a way forward, but we want to, that's where we're heading. We're heading towards getting a series of exemptions or a series of pathways in the law to regulate the construction of landscape rehydration works. Nobody wants someone dumping their tyres, their old tyres from the property in the creek and saying, well, I'm doing a leaky weir. That brings the work into disrepute, and it does not have the effect that they want. And so we're working with these guys and hopefully with the departments to come up with a pathway. So if we can get 5 years down the track and they accept that that's not a water taking for which they need a licence, and that the steps that we're taking in designing our leaky weir satisfy what would normally be under a controlled activity approval, because I'm doing works in water and I'm disturbing only the amount of vegetation that is absolutely necessary to do it, and I'm revegetating, then perhaps that is all I might need, a complying development certificate. Now that's our hope, but we don't know whether we'll end up there yet. So, but we think we've made some good progress this week.